Hi, this is Patrick Henry, the CEO of QuestFusion with the Real Deal What Matters. I'm here today with Jeremy Glaser, who's an attorney at the law firm of Mintz Levin. Jeremy serves as the co-chair of the firm's venture capital and emerging companies practice. And Jeremy has experience working representing both venture capitalists as well as entrepreneurs and startups, and so he's got experience on both sides of the fence there. We've had Jeremy as a guest on the show before, and you should definitely check out his initial interview he did with us, which kind of explains a little bit more about his background. Jeremy has so many awards and recognitions, it's hard to name them all, but most recently he was named the San Diego Venture Capital Law Lawyer of the Year, so congratulations on that. And Jeremy has also served as a past president and a board member for the San Diego Venture Group and is a member of the American Bar Association. So welcome, Jeremy.
Thanks, Patrick.
Today we're going to be discussing non-disclosure agreements, or NDAs as they're commonly referred to, and the different types of NDAs, and what are the key components that you need to include in NDAs as a startup or as an entrepreneur. So, Jeremy, can you describe kind of in layman's terms the different types of NDAs?
Sure. So let's just start with even why do you need an NDA, right?
Okay.
So most companies, they're developing some new product, some new technology, and that's their secret sauce. And the last thing you want to do is be out there talking to people about it, and then they can go ahead and say, oh, that's a great idea, and run off and go start their own business.
Yeah.
So really the purpose of the NDA, the non-disclosure agreement, is when you meet with somebody to have them agree in writing that what you're sharing with them is going to be confidential.
Mm-hmm.
And specifically agreeing that they're only going to use that information for purposes of the specific relationship or conversation you're having.
Okay.
So they agree in writing that they are not going to go off and go start another business using your idea, or go share your information with somebody else, or go write an article about it and publish it. So it protects your idea.
Okay.
So really important that you have a form that you use when you go out to meet with people. And we'll talk about there's some instances where you can get NDAs and some instances where you can't.
Right.
But basically, there's really two flavors. That's what we call a mutual NDA,
Yeah.
and then there's a one-way NDA. And they're what they sound like, right? So the one-way is, I'm sitting down with you, Patrick, and I've got a great idea, I want to share it with you.
Mm-hmm.
I make you sign a one-way that says, I'm giving you information, you're going to keep it confidential.
Mm-hmm.
A mutual one is where, let's say, we're talking about negotiating a deal.
Yeah.
And you might be providing some service to me, and I'm going to be providing some service back to you, so we both have secrets we want to keep. And
Yeah.
that's what we call a mutual NDA.
And rarely have I seen anybody willing to sign a one-way NDA. So,
Because everybody always thinks they have some secrets themselves. Yes.
Exactly.
Yes.
So in my experience, I mean, you got a confidentiality provision typically, and you have a proprietary invention, something about the technology. I mean, are those things always included in all NDAs, or kind of what are the components? Let's just talk about from a mutual NDA. So we're sharing information with each other. We want to do it in a confidential way.
Mm-hmm.
What are the rules associated with that? Typically there's a term or a length of time that information is in existence. I mean, what are some of the other provisions that you commonly
Sure.
see in NDAs? And does Mintz have a form NDA that they have for startups or things like that?
Sure. So the answer is yes, we do. We have forms of both mutual NDAs and one-way NDAs. We actually have a fixed fee program we provide to startups that we give that NDA for free.
Okay.
Now, granted, the form is thorough and it's great and someone could use it, but there's always things you need to be aware of as you're negotiating
Right.
off of any document. The form is just a starting place.
Yeah.
So a couple of things you mentioned. So one thing that you need to be focusing on when you're negotiating an NDA is what's confidential. The scope of what has to be kept confidential is really important.
Yeah.
Because there might be a lot of information being shared that's not private, that maybe is already in the public domain.
Right.
Or maybe you already knew before you actually met me.
Yeah.
So the definition of what we're going to consider confidential and therefore what can't be used is important. Otherwise you could find yourself potentially being exposed to a lawsuit by some third party or the party who you have the NDA with, when you had every right to use that information, but you didn't make that clear in the agreement,
Yeah.
and you've now bound yourself to keep something confidential that really you shouldn't have had to. So the definition of confidential information is a really important part
Okay.
of the NDA and should be carefully reviewed and make sure it fits the specific circumstance. You mentioned the term. So you certainly don't want the NDA to last forever. At some point, theoretically, the information just becomes so old and cold that it really doesn't have to be kept confidential anymore.
Right.
Now, that's not always the case. There is some information that may be valuable sort of forever. And
Yeah.
you could certainly provide that this person agrees to keep that information confidential and not use it forever.
Yeah.
But that's unusual. You would typically have an NDA have some sort of a set term that, maybe a couple of years, 3, 5 years at the most, and then the agreement would go away.
Okay.
There's so many other aspects that one can negotiate. The one thing I always want to warn people about, especially in the technology space, is that you can sometimes end up in a situation, particularly with a large company, where, and I don't mean to say that they're tricky, but in trying
Yeah.
to protect themselves, they will draft the agreement in such a way that things that are derived from the conversation, so I share with you an idea,
Yeah.
and they don't use that idea, but they walk away with some
Residual
knowledge in their
knowledge.
heads. Exactly.
Yeah.
And they sort of sometimes will carve that out.
Yeah.
And that could be very dangerous to a startup company because you could have ended up giving away something very valuable without knowing it, and now the big company can run off and go use it, and because of the way they drafted the NDA, you have no way to stop them,
Right.
even though it was derived or residual,
Yeah.
as they call it. You
Yeah.
obviously had to deal with this before.
I've had it, yes.
Yes.
They can be bullies.
Yes, they can. The bigger the company, sometimes the more bully.
And less flexible. I mean, they have a lot of intellectual property and they want to make sure that they're protected, but they also feel like they should be able to do anything they want to do. So as an entrepreneur, you have to be very careful in those situations with things that are really intellectual property. But I think a lot of times entrepreneurs get wrapped around the axle on what really is something that you need to have as confidential. And, it's as an example, you typically a venture capitalist or even most angel investors will not sign non-disclosure agreements.
Exactly, they will not.
So you need to find a way to share information about your business and if you're raising money in a way that you don't have to get people to sign an NDA because they're not going to sign them.
That's
exactly
right.
I mean, what's your experience kind of coaching entrepreneurs about
Sure.
those kinds of things?
Comes up all the time, and you're exactly right. A venture capitalist and most angel investors will not sign NDAs, and the reason's obvious. They're seeing so many deals that if they're signing NDAs on deals, they don't know the next deal that they're going to see
Sure.
that might be of interest to them, and they invest in it, and they've signed an NDA with you, but they decided not to invest in your deal,
Yeah.
and now you're suing them, claiming, you violated it because they can't be put in that position.
Yeah.
So it's just not going to happen that you're going to get an NDA signed in that situation.
Sure.
So it's obviously built upon a lot of trust. And it's the same advice I've given to companies when they're considering a transaction with a third party or an M&A deal.
Yeah.
You need to sort of leak out the information.
Mhm.
You don't just walk into the meeting and give them everything.
Yeah.
You need to make sure that there's real interest, that it's serious interest, and over time, and as you get comfortable with the relationship, you can obviously share more and more of the information that you view as really important and crucial to your business.
Yeah.
So you're right. I always tell entrepreneurs, I want you to put together an executive summary
Yeah.
and a pitch deck that is non-confidential.
Right.
There's nothing in there that you would be worried about it ending up in the hands of a direct competitor of your business. If there's something in there that you don't want a direct competitor to see, you got to take it out. And there will be a time later when you're much further down the road with that investor where you can then share that kind of confidential information, probably once you've either gotten a term sheet or you're pretty darn close to getting a term sheet issued, at which point your interests are so aligned
Yeah.
that they obviously have no interest in sharing the information because it would hurt their investment at that point.
Right. So that's where they're in kind of a deeper diligence phase, but you need to have layers of information that basically you can provide stuff. Now let's say, I have my slide deck and I market, confidential and proprietary information to QuestFusion. Does that protect me, or do I actually need to get a signed agreement from somebody to make it confidential?
Yeah, so I think you always should mark things confidential, absolutely, right?
Mm-hmm.
But in the absence of an agreement from somebody that they're going to keep it confidential, you can't go sue that person and claim that they violated your confidential, because they could look at it and go, well, there's nothing confidential in there. I knew all that before. I didn't learn anything from what you sent me.
Mm-hmm.
So it's good just in case it ends up in somebody's hands, and so people will probably be a little more thoughtful about how they're going to treat it.
Yeah.
But in the absence of an actual agreement around confidentiality, you're not going to be successful at going after somebody who uses that information.
Now, how important is it to outline how confidential information is exchanged? I mean, I've seen kind of in my history where you have a meeting and you have to follow up afterwards and say, these are the specific things that we talked about that are confidential. Is that essential, or is it, if you don't have that, are you exposing yourself to a lot of risk, or how does that work?
Sure. So again, it really depends upon the terms of the agreement, and this is where, again, people, I think, get too comfortable that, a Form NDA is okay, right? They pull something off of the internet and just go ahead and use that without understanding its implications, and then they don't live by it. So the classic example is what you just described, right? Somebody pulls an NDA off the internet, they sign it, they think that they're protected now because they signed an NDA.
Yeah.
But the NDA that they signed says that in order for something to be confidential, it has to be marked confidential, and you have to identify it as confidential immediately after, or prior or immediately after the disclosure.
Yeah.
And so then they disclose all kinds of things in the meeting, none of which is marked confidential, and the follow-up doesn't happen, and now they've lost the protection because the agreement that they signed said for it to fall within the definition of confidential information, you needed to go through those steps.
Right.
You don't have to have that.
Yeah.
You can say, broadly define these areas, this type of information that we share is confidential.
Yeah.
So it really is a give and take and a negotiation. Now that whole sort of marking concept, I mean, look, it's obviously very protective for the person who's getting the information, right? Because you want to, and my argument to you would be, hey, I want to really know what you think is confidential so I know what I have to protect. We're talking about so much stuff, and some of it I know, some of it I don't know, some of it might be in public domain, some of it may not be. I can't possibly determine what that is, but Patrick, you know, because it's your information. So it's your obligation to make sure you clearly identify what's confidential when you deliver it to me or promptly thereafter. It's a legitimate argument, but it creates a procedure that could really blow up in your face if you don't follow it carefully.
Now, what if somebody, you have one of these conversations and you get the follow-up action and they have a bunch of stuff marked confidential and you're like, I know this stuff's in the public domain. And with the internet, it used to be hard, because without the internet. But with the internet, it's really easy.
Right.
Because I do have these conversations like, this is so secret and this is so... It's like you have the internet, it's like it's all over the place. So how do you challenge that, but challenge it in a way where you don't want to disrupt the relationship, but at the same time you don't want to be beholden to something that somebody thinks is confidential, but it's really not?
Yeah. So again, you start with the agreement and the definition. Most NDAs, confidentiality agreements, have a specific exception that says that if the information is in the public domain prior to the time of disclosure, and you can prove that from some written evidence, then it's not considered confidential information. It's sort of built into the definition.
So that's pretty easy, as long as you have a good...
As long as that carve-out's in there, and there's a number of sort of standard carve-outs that are important to have. They're important to understand and read and make sure that they work in the context of your specific relationship.
Now, does this basic kind of form NDA, the one that you have on Mintz Edge, does it cover things like with customers and with partners and with employees, and or do you need to tailor it for different audiences?
Very good question. So there's really two broad universes. There's the NDA that is used for customers, what I'll call broadly business relationships.
Commercial business type stuff.
Exactly. And then there's a whole separate confidentiality agreement that's for employees and consultants. And that we actually use a different name for. We call that a proprietary information and inventions agreement.
Right.
And that is a very different agreement. That's something that every company should have at the time they form their company, and that every employee and every consultant who ever works with the company needs to sign.
And I've definitely been in situations where companies haven't managed that process well, and you get into an M&A discussion, and you're like, okay, now we got to round up, these 5 guys that never signed anything and these 4 consultants that never signed anything, and try to get people to sign stuff after the fact. And
it can be a big deal, and
crazy.
It can really matter, because especially if they were involved in the process of inventing any of the technology, you have some real issues if they've not signed that document about ownership and whether you have clear title. So that's a hugely important document to get signed by
Yeah.
every person that is an employee or consultant. And in fact, I talked about, we have these forms and this Mintz Edge package.
Yeah.
Part of the Mintz Edge package for companies and part of our fixed fee program is they get a form of proprietary information and inventions agreement so that they have that from the very beginning, so that all their employees and consultants are signing the appropriate document.
So within those two universes, those two basic form agreements that you have, how frequent, or do you have the data on how frequent people use them as is versus need some level of customization?
Sure. So the employee proprietary information and inventions agreement is pretty much used as is. The only
Okay.
exception is there's a specific section in there where an employee can list inventions that they invented prior to their working for the company and that they want excluded.
Okay.
So that's really the customization for that. That's usually not negotiated. It's usually those inventions are listed, the employer will look at them and make sure they agree, but rarely are you really changing the language of that specific agreement. On the flip side, the NDA, the more commercial business terms NDA, that's really more typically where you're getting negotiations. Now look, early startups and they're moving fast and the forms is sort of adequate to protect them, but you got to still make sure you know what's in there, so you know that you're complying with whatever requirements are in the form that you've elected to use. So it works without a negotiation, but I always urge people to make sure they really understand it and don't just sign it away without really understanding what it says and what it requires of people.
Now, the bigger company, like it's kind of like the David and Goliath, or probably not David and Goliath, because actually the little guy won in that situation. The more typical situation where
Yes.
the bigger company's like, well, you have to sign our NDA.
It's our form.
And, it's our form, it's our thing.
Right.
How, as a startup, do you deal with that and make sure you're not getting in a situation that is going to compromise you a lot?
I know it's hard because no one wants to spend the dollars on legal fees, but I tell every startup you should never sign a Form NDA put in front of you by a large corporation because there's gotchas in there.
Yeah.
And you want to make sure.
And you'll regret it later for doing
And it could hurt you later.
Yeah.
It could mean that you've lost some protection of some important information.
Right.
It could mean you've allowed a competitor to get into your space who wouldn't have been there otherwise
Yeah.
by sharing that information. It's really worth it to run that by. It's not an expensive review to have an attorney look over the NDA and at least point out to you the issues where you have exposure.
Sure.
And you can go back to the other company and at least try. And,
Yeah.
even if they won't make changes, at least then you're aware
Yeah.
of where the risks are.
Yeah,
and
you
maybe
might
you'll-
share information differently than you would otherwise,
Exactly.
thinking that, oh, I've got all this protection.
Exactly.
Okay. And then kind of this, we haven't talked about it, but is there a third form of NDA related to M&A transactions where you're kind of exchanging data room information? And
Yes.
can you talk a little bit about that and kind of what that's all about?
Sure. So when you're going into M&A negotiations, again, clearly there's going to be a form of NDA that will be put together for sort of upfront the initial companies you're talking to about your business, because usually you're talking to
Yeah, like
multiple
there's a step one
companies.
and a step two. So on step one,
Right.
what's included in that?
So again, it's really the initial one. It's not that it's really different from sort of the business commercial terms NDA. What it does though is it sort of is specifically tailored around the M&A discussions. So again, we go back to this whole what is considered confidential. It really is driven by that definition of the kind of information that's going to be shared.
Yeah.
So that's really where the tailoring and the sort of M&A NDA comes from, as opposed to a more standard business type of NDA. The reality is they're quite similar, right? They have periods of time where the information cannot be shared.
Yeah.
They have some specific exceptions where things are outside of the definition. Again, in the M&A context, usually there's much more sophistication going on at the time of the exchange. So that's where you're more likely going to see the kind of marketing things we were talking about.
Right.
Because people are in a process that is much more sort of formalized than sort of an ongoing business conversation. So those NDAs will tend to be a little bit tighter. They'll tend to be a little bit more formal, and they'll have more process built in.
Yeah.
Whereas the more business NDA, we try not to do that because we realize most companies aren't going to be following procedures as they're having multiple conversations with lots of different potential customers or suppliers or whatever.
Okay. And then, I've seen like non-solicitation baked in a lot of times in these M&A types of NDAs, which means, they the company that you're potentially selling your company to, they can't recruit your employees if you're exposing your employees' names and what they do and all those kinds of things.
Yes.
Is that pretty common, or is that, you see a lot of pushback on that in M&A transactions? Or
So, yeah, I mean, basically, and I think you're pointing out a really good point, that very often you'll see snuck into these not only a no solicitation of employees, but what we call a lockup.
Yeah.
That, big companies will put in an NDA that you're agreeing to effectively take your company off the market.
Yeah.
Which is obviously unacceptable and you would never agree to, but you'd be amazed how often they
try to just sneak it in there,
and think that someone is so excited about the potential of being sold that they're going to get this free look period on the company. So you got to be very careful and thoughtful if you're ever being given the NDA by the potential acquirer, as opposed to you providing your form out to the people who are sort of looking at the company. And yes, that in this context, but even in the context of the typical customer relationship, very often you will have a no solicitation of employee provision on the theory that in both of those situations you're being exposed to the employees of the other company.
So sometimes it's a mutual non-solicitation
Correct.
type of thing. Okay.
Correct. And again, those are negotiated, how long.
Sure.
And again, there's some exceptions you need to build in. I mean, the most obvious one, you don't ever want to be in a situation where you can't hire someone who's quit their job and is out looking.
Right.
I mean, you should be able to hire that person.
Right.
So you need to build exceptions like that. And then you can get a lot more creative on some of the exceptions on the solicitation of employees. So again, it's a bit of a broken record, but it is important to actually understand the context of the NDA that you're putting in place, to actually review it carefully, to have preferably an attorney, but someone who's very familiar with NDAs, review it as well, so at least you can know where the pitfalls are and where your risks are, and hopefully go in and try to tighten some of these things down to make it work for your particular business.
Okay. Now let's say, hypothetically, we've signed a mutual non-solicitation agreement, and you have some engineer working for you, and he hates working for you, and he's like, "Hey, Patrick, I really want to come work for you, and we have this agreement in place. Am I able to hire that person because they've contacted me, or is it,
Depends again on the language in the agreement,
Okay.
right? So some no solicitations are actually no hires, right? You agree that for a year you won't hire
You'll never
anybody.
hire anybody from that company.
Right.
So you got to be real careful
You got
what
to
you're
be
saying.
really careful. The language matters.
Yeah. Okay. And then, in your experience, I think a lot of times entrepreneurs get very paranoid about somebody stealing their ideas. And in my experience, you need to protect how you do stuff, but what you do, you need to be able to explain that in a way that doesn't include confidential information. So, do you really see venture capitalists kind of ripping off ideas from companies, or is this a legitimate concern by entrepreneurs? Or
It's certainly not as to venture capitalists. I mean, think about it. What venture capitalist is going to stay in business if they have a reputation of taking companies' ideas and running them off and starting new companies and giving them to you're going to destroy your business.
Yeah.
So, no, I don't think I can honestly say in 30 years I've never seen a venture capital firm do this. However, I have seen companies do it.
Yeah.
And so when you're engaged in negotiations, especially as a small company, and you're trying to show your technology to a potential strategic investor or potential customer, it's quite important that you have that NDA in place. Unfortunately, I've seen situations where large companies with a lot of resources have seen a technology and have said, not patented, and off they go. And even though there might be a case to go sue them, just the cost is so prohibitive to go after them on it that unfortunately I can think of one situation where my client folded up shop and went out of business because the company took their idea and ran off with it, and there was really nothing they could do because they couldn't afford to sue them, and it was a terrible situation.
I think this has been a really good, comprehensive discussion. There's one thing that in my kind of experience where you still have to be careful, and it used to be, Korea, now it's primarily China, where even if you have a non-disclosure agreement, or even if you have employees over there and they've signed a proprietary invention, whether it's cultural or whether it's whatever, you still have to be very careful on how you protect your intellectual property, even if you have the right agreements in place, because your ability to pursue people in that environment, or, maybe you're able to sue a customer, or maybe you're able to sue a supplier, But I think exchange of confidential information, use good judgment associated with that. Even agreements alone are necessary, but not sufficient. I guess is the way that I would put it.
Patrick, I totally agree. I tell all my clients that all an agreement does is it gives you the right to sue the person if they violate it.
Yeah.
And then the question is, how much money is it going to take? How
Yeah.
much time is it going to take? Can you in fact get a remedy, like you said, based on where the person lives?
Yeah.
So I always start, trust.
Yeah.
If the trust isn't there at the beginning of the relationship, there's no agreement that's going to protect you.
Right. Absolutely. Yeah. I mean, all it does is if you have people that you're dealing with where they're trustworthy and you have that type of relationship, then it outlines how things are done in the event that something goes wrong.
Exactly.
I think it's the same way with employment agreements. It's like I'm not requesting you to do an employment agreement with me because I don't trust you. It's just defining how we deal with things in the event that something goes sideways.
Exactly.
And I think NDAs are kind of in that same genre.
I agree, and at least, and I will say though, but they do give you at least that option
Sure,
to go after someone who for whatever reason becomes a bad actor and runs off with your information.
Yeah.
Now that said, in a whole separate conversation I know you'll be having with others, patents, trade secrets,
Yeah.
trademarks, copyright.
Yeah.
There's a lot of intellectual property rights that are very important to have in addition to an NDA.
Yeah, for sure. Well, this has been very informative as always. Thank you very much, Jeremy. This is Patrick Henry from QuestFusion with The Real Deal, What Matters.